Minister in the Office of the Attorney General.
Mr. President, I thank you most sincerely to jump into this debate. Of course, joining in with the Attorney General and echoing how critical, how important this legislation is in improving the criminal justice system. Mr. President, of course, I have to use the opportunity in my contribution, or part of my contribution will be to, of course, address certain comments and questions, and more so comments and statements that were placed on the record by Senator Lakshmi Dayal, and then, of course, try to address certain questions asked by Senator Thompson-Ayi, and that's the place I will begin before I jump into the crux of my contribution. I believe this is the best place to start because, of course, the AG would have given us a great, he would have done an excellent delivery in his piloting by going through the length and breadth of the legislation, and more so I appreciated that he focused on the clauses in the bill that seeks to really bring about a radical reform in the criminal justice system. Now, Mr. President, I would have to say, most respectfully, today in preparing to answer to some of the comments made by Senator Lakshmi Dayal was indeed quite easy. And the reason for that is because I'm not sure if her learned friend in the House of Representatives, I'm not sure who prepared whose speech, because the exact questions, it was a copy and paste, unfortunately, for the opposition, but fortunately for me, in preparing for this debate, because the exact questions and concerns that were raised by Senator Hussain in the House of Representatives, it was simply echoed through Senator Lakshmi Dayal. So, as I said, I'm not sure if it's one speechwriter who writes in whose speech, if it's a copy and paste that takes place on that side, but it certainly, Mr. President, makes it easier for us on the government bench in preparing for this debate, because we always can foresee what questions and what concerns they are going to raise. And of course, that being said, Mr. President, there are 6 issues that I will seek, 6 concerns that were raised by the Senator that was also raised in another place, which I would attempt to rectify and add my 2 pence to. And I'm sure, of course, the Attorney General in his winding up will deal with other issues, and of course, other members of this government bench, as they jump in, they will deal with those issues as they come up. One of the issues, and I want to jump into that issue first, is that because, of course, the learned Senator Thompson-Ayi would have raised that question. She would have asked the question. The comment was made on not seeing the definition for appropriate adult in the Children's Act. The Act was amended, Mr. President, by Act number 15 of 2018. And by virtue of Section 10, it amended Section 3 of the Children's Act to insert the definition of appropriate adult. So I just wanted to, mention that for the benefit of Senator Thompson-Ayi, and go a little further, because Senator Lakshmi Dayal, in her contribution, also raised the issue and her concern of the term appropriate adult. And as I would have alluded to earlier, Mr. President, by virtue of Section 10, it amended Section 3 of the Children's Act to insert a definition. And for the purpose of the record, Mr. President, what I can say is that pursuant to the appropriate adult is used in Section 3 of the Children's Act, and for the purpose of the record, for us to understand that there is clarity relative to this definition that already exists in the Children's Act, I will read into the record what it has been defined as, or what it is defined as in Section 3 of the Children's Act. And it means a person 18 years of age and over who is a social worker, welfare officer, justice of the peace, an attorney at law, any other reasonable responsible person with whom the child is comfortable, or there's also F, in the case of a person with a disability, the appropriate professional, but does not include G, an accomplice. And then we have H, a person not being a parent with previous convictions relating to a child or affecting that child within the last 10 years. Then we have I, a person not being a parent on probation. J, a person of the police service or any employee in the police service other than I, a family member, and then, one, and then we have 2, a person who is well known to the child, 3, a person with whom the child is comfortable, and then that entire section, while section 3, I'm reading it into the record, Mr. President, because the term appropriate adult for the purpose of the record is clearly and properly defined in the Children's Act. And what we would have done in this particular legislation, Mr. President, we would have simply transposed that definition into the bill that appears before the Senate today. So, for the benefit of course, Senator Thompson-I, and of course, for the benefit of the statement made by Senator Lakshmi Dayal, of course.
Okay. For amending the laws online. I have said in this parliament more than once that researching the laws of Trinidad and Tobago is a researcher's nightmare. We have people all over the world who are checking laws, and you can go to other jurisdictions and you can see updates in the law. What is wrong? Is there nobody with that responsibility in Trinidad and Tobago?
If I may respond, of course, there are persons with a responsibility, but of course, Senator, sometimes there's a real challenge in micromanaging persons with certain responsibilities, but I'm sure, and ensuring that they do what they ought to do. And that certainly, personally, I can apologize for that trauma that you would face, and of course, colleagues at the bench may face in doing their research. And hence the reason, Honourable Senator, I saw it was necessary just for your benefit, of course, to identify the piece of law that would have brought that necessary amendment. And I'm sure, given the modus operandi of the AG, who currently serves, I know he will go back to the office, and I will equally do my part, Senator, to ensure that the needful is done, so that at least we can assist, researchers like yourself, and of course the wider Trinidad and Tobago, in locating the necessary legislation when researching. But I do hope that the bit that I would have provided can now just respectfully guide you to where the amendments do exist. And just to continue, Mr. President, of course, the appropriate adult has been adequately dealt with in the Children's Act, and what we have done in this legislation is simply transpose that definition here. So that was one of the queries, of course, that was raised by Senator Thompson-I, and it was also an issue that was raised by Senator Lakshmi Dayal in her contribution. If I may go on to another point made by Senator Lakshmi Dayal, Mr. President, Senator Lakshmi Dayal stated that the criminal justice system is a topic of grave concern, which I agree with the Senator. She also said it's a topic that continuously rears its head, but then went on to speak about not agreeing with the Attorney General about, the necessity to have a cross-examination and lengthy cross-examination at a preliminary inquiry stage. If I may, I don't want to misquote the Senator, and these were the verbatim notes that I took. Senator Lakshmi Dayal stated that she didn't necessarily characterize what takes place in a pre-trial place as totally irrelevant. She spoke of there being a prolix of cross-examination and an abuse of pre-trial processes, and that at a PI stage we have a heavy reliance still on witness evidence. Mr. President, considering the purport and the intention of this bill, which is to inter alia improve the efficiency of the criminal justice system, respectfully, Mr. President, Senator Lakshmi Dayal's argument holds absolutely no weight. And I will say that because we are here to retain cross-examination, Mr. President, at the level of, we are here at the PI stage, it would continue if we are here to continue cross-examination at the PI stage, respectfully, I place on the record, Mr. President, that it will to a great extent stifle the rate in which we are able to move these matters through the system. And, just from a very personal experience, Mr. President, and also in the benefit and the interest of the accused persons that appear before the court, the AG, of course, in his piloting would have spoken when he dealt with the issue of cross-examination, particularly at the PI stage. Something came to my mind immediately. Yes, a PI, in essence, is a pre-trial, the trial before the trial on the indictment. And, there's one very reason why the accused person spends an exorbitant amount of money in hiring the best counsel that they could possibly find to represent them at the PI stage. And this is not the trial. This is just to determine if you have a trial to answer to. It's because of the issue of cross-examination. And the reason for that is because, Mr. President, if you have bad cross-examination taking place at the stage of the PI, what you have is the accused is now locked into that evidence. And there is no way of getting out of that evidence, that bad cross that he's locked into at a PI stage. And then he's committed, and this is what goes on to the High Court. This is what goes on, to the trial stage. And personally, in instructing Mrs. Elder on certain matters, I have seen where not even senior, being creme de la creme in criminal law, based on what happened at the PI stage, it was absolutely difficult to try to even present a decent case for your accused person when the matter on the indictment was actually heard. And that is just something, at least in the interest of the accused as well, Mr. President, that I personally, when the AG would have spoken in his piloting, would have mentioned and spoken about, cross-examination that take place at the preliminary inquiry stage. I can say, adding my own little 2 pence, that I believe that sometimes that botched cross at the PI stage, it actually negatively impacts on the accused person when they actually now have to answer, when they're committed and there's now a trial on the indictment. And as a consequence of that, Mr. President, from just that very personal experience and that personal place, I believe beyond just the whole argument of, not having lengthy cross and the system moving through the system quicker, beyond that argument, which of course is one of the fundamental reasons why we want to abolish these preliminary inquiries, I believe in the interest of the accused as well, Mr. President, by not opening a window for him to have botched cross-examinations. And of course, he's committed, and then he has a fairer chance, of course, at the trial of the indictment to be able to lead his evidence and, of course, to be able to lead his case. And I just wanted, just based on my experience, Mr. President, to put that on the record. Now, Senator Lakshmi Dayal, Mr. President, spoke about her concerns. She raised her concerns on the proclamation clause that exists in this particular piece of legislation. And of course, mentioned, in talking about the proclamation, the senator would have spoken about, in essence, she's hoping that we don't wait too long before the bill is proclaimed. And in her contribution, she would have spoken about the issue of resourcing, and she mentioned, I know for sure, I took note of that, the issue of staffing requirements in order for AJIPA, in order for this bill to be able for us to breathe life into this bill. Mr. President, just for the purpose of the record, again, I know on the judiciary's website, for example, in my preparation for this bill, I would have seen that the judiciary stated that currently there's an audit of 19 masters of the court, and it's public information that is available on the judiciary's website. But what I was even particularly pleased with is that I came across an advertisement that was placed on the website as well, where the judiciary has already started advertising for positions of masters. And that, to me, it shows that the judiciary has already been proactive and steps are already being taken to ensure that their current complement and their current audit of masters will be filled by the time that proclamation comes along. Mr. President, I want to also say that the issue of, staffing at the judiciary, the issue of the DPP, what has to happen at the DPP, most respectfully, I want to state that that ought not to be a stumbling block in the passage of this bill today. The judiciary and the JLSC, of course, they have their which, as I said, I'm proud. I want to applaud the judiciary in particular, because I saw that advertisement that is already out, where they are recruiting masters, and there's the whole job the whole advertisement that speaks to the salary, the terms, the conditions, the requirements. I want to say, so I am pleased that has already taken place, and it's in stream, I believe, and I'm not doing PR for the judiciary, but I think applications close by, I think, the 3rd of July. So I'm hoping that the persons who are qualified and who wish to serve as masters, can go onto the judiciary website and, probably offer themselves to serve this country and, of course, the judiciary at that level. But what I wanted to say is that even though staffing is a real issue, whether it's at the DPP, whether it's at the judiciary, certainly that's not a reason why, or that ought not to be a stumbling block in the passage of this bill today. As a matter of fact, Mr. President, I had the benefit to sit at the LRC with our learned Attorney General. And, that is in my substantive presentation, but as I raise the issue of the AG, I want to applaud the Attorney General. I have to commend the Attorney General, because the Attorney General came in at our new Attorney General. I sat at those LRCs and I saw his interest, his intent, his focus on delivering and ensuring that this bill, I saw the care and diligence that was applied by our current Attorney General in those consultations that took place with the judiciary and other stakeholders. Mind you, and the AG wouldn't say it, but I will say it because, of course, of the technology. We had LRCs sometimes that went into 8, 9, into the night, and the AG is there with all the energy, all of the enthusiasm with our stakeholders trying to make this thing right. And I have to use the opportunity again to applaud the AG and congratulate him for the work that he has done since he has come into the ministry, and more so for what the bill that currently appears before us. Mr. President, the judiciary, and why I'm saying that is because in having the benefit of sitting in those LRCs, with, of course, I must recognize the chairman of the LRC as well, Minister Al-Rawi, and our AG, I understand fully that from the get-go, the judiciary supports this bill, and I have every confidence, Mr. President, that as it relates to staffing issues, that the judiciary is competent and they are able to manage their affairs, and they, of course, will work with the JLSC and the necessary entities to ensure that once this bill is proclaimed, that they are running on pure gas and on full cylinders, and therefore we can really see this system being operationalized and bringing forward the changes that I know both the judiciary and, of course, the government is looking forward to once we breathe that necessary life into AJIPA. And I just wanted to place that on the record as it relates to the issue of staffing raised by Senator Lakshmi Dayal. Of course, the AG would have already spoken in detail about his work and his continuous work and efforts with the Office of the Director of Public Prosecution. And I may sound utopic and I may sound optimistic, but you know what, Mr. President, in the times that you need leaders like myself who believe that there is hope and there is abundance in Trinidad and Tobago, just as every member of this government believes in. And I have every confidence that with the continued work of the Attorney General, his team that he has assembled, a very competent team that he has assembled to work with him in resolving whatever outstanding issues that may exist in the Office of the Director of Public Prosecution, I believe with that continued dialogue that we will be able, in short order, Mr. President, to see the reformation and the improvements being brought to the Office of the Director of Public Prosecution, an officer whom I have the world of respect to, and I've always said that to the DPP's face, even behind his back, and I am sure that in short order, as I said before, those changes will be brought that will improve the complement and the issues that exist here. All that being said, Mr. President, I want to allay the fears of the general public as it relates to whether or not the proclamation clause is just going to be used as another stumbling block or another block to derail us from proclaiming AJIPA. I have every confidence that upon the passage of this bill, because systems are already in place, both in the Office of the Director of Public Prosecution, both at the judiciary stage, and certainly from the Office of the Attorney General stage, I have every confident that this proclamation clause is not going to be used to further derail the bill. However, what it will be used, as all proclamation clauses are used for, it gives the additional little time that may be required for those who have not fully put their houses in order to put things in place so that once it is proclaimed, we can be able to see those changes. Mr. President, I now want to turn to the issue on the search warrants raised by Senator Lakshmi Dayal. And again, it is a copy and paste, unfortunately, from statements made, that I would have seen on the Hansard of in another place by MP Hussain. And Mr. President, like her colleague in the other place, the question was raised on the issue of search warrants. It was stated that the law now allows for a master of a high court to have jurisdiction under AJIPA. Again, Mr. President, for the purpose of clarifying the record, the distinction here is made between an intercept warrant pursuant to Section 6 and 8 of AJIPA. And I strongly suggest both, her colleague in the other place and the senator, perhaps they would want to go back to the AJIPA legislation and would want to pay particular attention to Section 6 and Section 8, and you will see the distinction that is made in the legislation between what we are speaking, the search warrants we are speaking about here, as opposed to the intercept warrant that AJIPA deals with. So I wanted to place that on the record as it relates to the law. Mr. President, I also want to say that the search warrants that we're speaking about here is distinctly different, all right? The intercept warrant is distinctly different to a search warrant, wherein stored, and I want to read it from the legislation, wherein stored communications, stored data, and communications data are required. These are currently issued under Section 5, Mr. President, of the Preliminary Inquiry Act and are obtainable by a police constable. So I had to make the distinction because they are tying up themselves when they talk about search warrant, Mr. President, respectfully. What AJIPA deals with is distinct and separate and apart from what is being dealt with under this piece of legislation. And I felt that there was a need for me to rectify and clarify the record as it relates to that. Mr. President, like her colleague in the other place as well, Senator Lakshmi Dayal off the bat, verbatim stated, just like her colleague, this threshold for getting a search warrant is too low. It was, again, a copy and paste. To deal with that issue of the threshold being too low, Mr. President, again, I have to revert to the law as it relates to search warrants. Mr. President, the standard is the same. The standard for obtaining these search warrants is the same throughout other pieces of legislation in Trinidad and Tobago, Mr. President. As a matter of fact, this is the threshold which is currently upheld by the Criminal Procedure Act. And I see a criminal practitioner here who's representing the Senate, the opposition today. I'm sure Ms. Sira Bisram is familiar with Section 37 as well of the Summary Courts Act. And as a practitioner of the criminal law, and again, I'm referring respectfully through you, Senator, that Senator Lakshmi Dayal and her friend in the other place, they go to the law again, go to Section 37 of the Summary Courts Act, and Section 37(1) in particular says the information is given on oath to a magistrate or a justice that there is reasonable cause for suspecting that, and of course it goes on to speak to in obtaining a warrant. So what we have is in Section 37 of the Summary Courts Act speaks to the same standard that they believe is low in this legislation, Mr. President. The Summary Courts Act of Trinidad and Tobago is the same exact standard that is applied when it relates to obtaining a search warrant. If I may take my colleagues in the Senate further, because my answer refutal to that is that the standard is not low, it is just simply in alignment with other pieces of legislation. The same standard apply in other pieces of law. One piece of law I would have spoken to is I spoke about the Criminal Procedure Act, I spoke about the Summary Courts Act. If I may also know, and I know Senator Bisram may be familiar with Section 30 of the Firearms Act. Section 30, Mr. President, as it relates to the obtaining of these search warrants, is the same exact threshold. And if I may read into the record, Section 31, it says a magistrate or a justice of the peace, on being satisfied by information and oath that there is a reasonable ground for suspecting that an offense, suspensory that, will then, of course, and the section more goes on to say, they will grant the search warrant, and so on and so forth. But what I had to simply they came here, talking about these search warrants as if there's some kind of underhand reason. And Mr. President, this is good law. And I want to commit this law to the people of Trinidad and Tobago by saying that we have dealt, one, I made the distinction between that intercept warrant that they would have spoken about. I would respectfully, through you, suggested to my colleagues to go, my friends on the other side, to look at Section 6, Section 8 of IOCA. They will see the distinction. And then I would have gone a separate step, a further step, Mr. President, in disputing their arguments and their concerns about these search warrants. In looking at existing law, Mr. President, the Criminal Procedure Act, looking at Section 37 of the Summary Cause Act, looking at Section 30 of the Firearms Act, to say that the standard is not too low. What we have simply done is apply the same exact standard that is used in other pieces of legislation as it relates to the obtaining of search warrants that appears before us. And I had to clear that record. I would have hoped that, persons with their experience, Mr. President, that they would have familiarized themselves with the law. But it is what it is. That's why we are here as a government bench, to add clarity and clarification, and add and assist the opposition in understanding the good law that we are bringing to the people of Trinidad and Tobago today. Mr. President, and of course the issue of indictment was raised. And as it relates to the issue of indictments, Senator Lakshmi Dayal spoke about her concerns about where indictments are placed. And I have to say that one of my particular, all I want to say, Mr. President, especially in relation to the issues of indictment, I know Senator Lakshmi Dayal says if the DPP lays a voluntary bill of indictment, he is now subject to a sufficiency hearing. Mr. President, for the purpose of the record, Section 19(1) now requires all indictments, including a voluntary bill of indictment, and I want to read it, under Section 6(2) to be subjected to an initial and sufficiency hearing, yes. This upholds the power of the DPP to do his voluntary indictment. But at the same time, and this is the point that I want to make, Mr. President, but at the same time, it still allows for a matter to be adequately case managed so that all necessary documents are before the court for the trial. So yes, that is why particularly I'm supporting the place in which indictments we are requiring that indictments are filed, because we are not usurping the rights and the powers of the DPP. That is still intact. But by moving the indictment at the beginning of the sufficiency, to the place where we have now moved it, Mr. President, what we are doing is that we are now having an ability to aggressively and adequately, Mr. President, manage when that indictment is filed and ensuring that all documents are before the court in a timely manner. Mr. President, this is a real issue. I recall in preparation for this, I would have pulled some stats on indictments. And it is, and again, this is not, of course, to cast any aspersions on what happens in the Office of the Director of Public Prosecution at all. But I have my concerns as a citizen of Trinidad and Tobago. When I look at, for example, let's look at 2013 in the Port of Spain division alone, Mr. Port of Spain courts. We had 105 indictments alone that is filed. We have in 2014, you have 129 indictments. And this is from thousands and thousands of matters. If you fast track from 2013-14 to 2023, we have 41 indictments, Mr. President. If we are serious about improving the criminal, and that is in the Port of Spain area. If I look at San Fernando, in 2013, we'd have had 78 indictments. There was a year in 2020 where we only had, well, of course, I know COVID was around, but we had only 4 indictments filed, Mr. President. Currently in 2023, we have 42 indictments, Mr. President. Certainly, if we are serious, which we are on this government bench, we are serious about, expediting the rates in which matters go through our criminal justice system. I have to agree with the Attorney General. I have to agree with the bill which appears before us at the stage and the place in which we have placed these indictments. And I'm hoping that, at least in the minds of the independent bench, that we get the support that we are looking for, recognizing if we go through. And I don't want to belabor the point of, what indictments have not been filed and what is outstanding. But but there is the statistics, sorry, Mr. President, are available. And it is concerning to me, not as a member of government, not even as an attorney at law, but just as a regular citizen of Trinidad and Tobago. Because, I heard Senator Lakshmi Dayal said it, the AG said it. When we deal with these matters, and I will echo that as well, when we deal with matters, criminal matters, remember there are several stakeholders involved. We're not just dealing with the accused, and we're not just dealing with a government who wants to pass good law and manage a country. We are dealing with the witnesses, we are dealing with families, we are dealing with the police. There are so many stakeholders. And once you don't have these indictments brought at a reasonable time, once you don't have them being filed at a fast rate, we will continue to have not just the criminal justice system being affected, but the lives of real people, Mr. President, being put on hold because there is a matter looming over their head. And that was just, I wanted to just echo that I am in full support, Mr. President. I recall also, Mr. President, during our consultations on this point of indictments at our public defenders department, they showed, of course, support for the voluntary bill of indictment being subject to a sufficiency hearing. And of course, I want to also place that on the record. So we have stakeholders, the judiciary, we have public defenders department as well, also supporting the position of where we want to now place indictments in these proceedings. And I just wanted to, put that on the record. So, Mr. President, I mean, those were the six of the points that were made by contributions made by Senator Lakshmi Dayal, that I just wanted to start my presentation looking at. Mr. President, you can tell me how much more time I have?
Finish at 4:23.
Well, I don't have much time, as I can see, but, Mr. President, based on what you would have said, Mr. President, again, I just want to start from the place. I know the AG would have mentioned the case of Hilroy Humphrey, and, of course, I'm not going to belabor that case, but, Lord Huffman, I just want to start by reminding citizenry, reminding even the accused and the family of the accused who are paying attention to this matter, that, of course, we are not usurping the rights, we are not trampling over the constitutional rights of the accused by the removal of preliminary inquiries, Mr. President, and also jumping into the case that the AG would have mentioned to. I'm certainly not going to run afoul of tedious repetition, but I would look at a statement made by Lord Huffman in particular in that particular case, Mr. President. And for the purpose of the record, Mr. President, Lord Huffman stated that prospective litigants or defendants, open brackets, or defendants in criminal proceedings do not have a vested right to any particular procedure, and there will generally be nothing unfair in applying whatever procedure is enforced when the case comes to court. Therefore, Mr. President, and close quotation, and that's taken straight out of the Hilroy Humphrey case. Mr. President, and this is especially, as I started off saying, for the families of the accused, the accused persons themselves, please, it is really for them to understand that certainly their rights to be heard has not been trampled upon, and there is no constitutional issue, Mr. President. An accused person will still be able, Mr. President, to enjoy the right of due process, and therefore, with this amendment, Mr. President, I reiterate there is no constitutional infringement by abolishing preliminary inquiries, as it does not, Mr. President, at all affect the accused right to a fair trial. Mr. President, I know the Honourable AG would have spoken in his piloting of the bill about this bill not being an infringement on the DPP's constitutional rights. In my presentation, of course, because time again is always my enemy in this hollowed place. Just briefly to reiterate and to join with the Honourable Attorney General in his position, I too agree as an attorney at law, Mr. President, that there is no infringement on the DPP's constitutional rights. All the rights of the DPP pursuant to Section 90 of our Constitution, Mr. President, is intact in this legislation, Mr. President. Mr. President, as a matter of fact, the DPP has control over, as we know, based on his constitutional rights, Mr. President, he has control over criminal proceedings, similar to other countries. In this bill in particular, Mr. President, if we look at Clause 8 of the bill, which amends Section 6, to my mind, that is a clause in this current bill that shows where the rights, that Section 90 rights of the DPP remains intact, Mr. President. And that example in coming out of this bill that appears before us deals with the issue of the discharge of the accused. In this particular clause, Mr. President, we see the director has a power under Clause 8, which amends Section 6(2) of the proposed bill to provide when he or she is of the opinion that a person should be put on a trial for an indictable offence, the DPP may prefer and file an indictment against the person whether or not a complaint is made against that person. Mr. President, if I go on further to the bill that appears before us, the proposed Clause 20 of the bill, which amends Section 6 of the bill, it goes on to state, and I quote, "A master shall hold a sufficiency hearing to determine whether there is sufficient evidence to establish a prima facie case or any indictable offence on an indictment." However, Mr. President, the proposed Clause 25 of the bill, which amends Section 24, provides, after reviewing the evidence submitted by the prosecutor and the accuser master finds that there is insufficient evidence to establish a prima facie case on any indictable offence or indictment, the master shall discharge the accused, taken in respect of the charge, and taken in respect of the charge shall be void. However, Mr. President, there's a safeguard in the bill that appears before us. The constitutional function of the DPP is not trampled, it is not eroded, and that is seen at Section 24(4) of the bill, Mr. President, that provides for instances where, and I quote from the section, I quote from the bill, where an accused is discharged, the master shall, on a written request of the Director of Public Prosecution, transmit within 14 days to the Director of Public Prosecution the record of the sufficiency hearing. It goes on, Mr. President, to provide at the proposed Section 5 that the Director of Public Prosecution may appeal the discretion of the master if the Director of Public Prosecution is of the opinion that the accused ought not to have been discharged. And what we see here, the right of the DPP to appeal that decision, Mr. President, to my mind, that bolsters his Section 95 rights pursuant to the Constitution. So I want, if there are any concerns, especially in the minds of the members of the listening public, who may believe that in some way or the other this bill seeks to trample the rights, the constitutional rights of the DPP, Mr. President, I simply suggest that they go to the bill, particularly pay attention to Section 24(4) of the bill, which is clause 25, Mr. President, of the bill, which amends Section 24, and more so Section which amends Section 24(4). Pay attention to that, and you will clearly be able to see that the powers of the DPP, the Section 90 powers of the DPP, Mr. President, of course, it remains intact. And just as we are not trampling over the rights of the accused, Mr. President, as I would have alluded to earlier, similarly in this bill, we are not trampling over or infringing upon the Section 90 constitutional rights, Mr. President, of the DPP. Mr. President, 3 more minutes. Okay, so in my 3 minutes, Mr. President, Mr. President, I just want to say there are many social benefits that, of course, that goes with the bill that we are dealing with today. We are looking at, by the removal of these PIs, I will strongly say, from a cost perspective, Mr. President, and cost for the accused, Mr. President, whereby now you have not having the trouble of having to hire well-learned senior counsels and the creme de la creme to run this trial for you. Accused is already in prison. Is a family tale to catch, unfortunately, Mr. President, to determine what are they going to sell. Sometime, God forbid, their kidney and liver, hopefully they don't have to sell in order to find money. And that is a reality. It's sad what families of the accused have to go through in order to be able to retain counsel. By the removal of these PIs, Mr. President, I strongly believe that there's going to be a significant significant social benefit to the accused persons as well as from a cost perspective, Mr. President. We also have from him being the accused being or her being denied her freedom for the length of time that they remain waiting for these matters to even come up at a PI level, Mr. President. That too is another social benefit. The AG, I know he would have more or less timestamp. I think it was a 6-month period based on the deadlines that are now given in the bill that appear, the timelines that are given in the bill that appears before us. I myself calculated it. You're looking at, hopefully you would have the sufficiency hearing if you have the adherence to the timelines that presented, that these matters can be dealt with in a matter of 6 months' time. And if you calculate the 28 days there and the 14 days there and the 15 days there, it really works up to about 6 months. That is in the interest of the accused, Mr. President, because we are looking at he's not just sitting there becoming a hardcore criminal waiting for his matter to be heard. We have that sufficiency hearings can be dealt. We have that their matters can come up. He knows whether he has a matter to answer to on the indictment or whether he is, whether he's discharged. That is a benefit. And more so, Mr. President, I believe by doing this is also a great benefit to the country. Mr. President, I remember in 2016, the then Attorney General would have revealed that the cost to the state to, let's say, maintain inmates on remand is about 10.6 billion per year to maintain 2,235 inmates. That was the cost, Mr. President. I believe we can reduce the cost and even save the country, Mr. President. Monies can be used elsewhere rather than taking care of prisoners who are waiting for their trial. I thank you, Mr. President.